And I'll read it for you all. I know you all probably know this, but just so it's in the record. A defendant aggrieved by unlawful search and seizure may move the court for the return of property in the possession of which is not otherwise unlawful. So that means, of course, if it's contraband, other drugs, weapons, or other things that wouldn't ordinarily be subject to being returned, and to suppress as evidence anything obtained on the grounds that the search and seizure without a warrant was illegal, or the search and seizure with a warrant was illegal because the warrant is insufficient on its face, there wasn't probable cause for the issuance of the warrant, or the warrant was illegally executed. The motion shall be in writing, which that one was, state facts showing the search and seizure were unlawful, which it was. The judge shall receive evidence outside the presence of the jury on any issue of fact necessary to determine the motion, and the burden of proving that the search and seizure were unlawful shall be on the state. If the motion is granted, the property shall be restored unless otherwise subject to lawful detention. Lawful detention would be contraband, of course, and it shall not be admissible, mandatory, shall not be admissible in evidence against the movement in any trial. The motion shall be made only before a court with jurisdiction to try the offense. If a criminal accusation is filed or an indictment or special presentment is returned by a grand jury, the motion shall be made only before the court which the accusation, indictment, or special presentment is filed and pending. The last time that we were in court, the court, Mr. Steele, I think we admitted for the court's consideration D1 through 10. Within those documents was the order Judge Newkirk entered. Can I have those, Christina? Do you have those? Do you have those ones? Are they up here? Okay, hold on, let me see. Okay, hold on. No, that's... Huh? Thank you. All right. All right, D1 was the accusation that was filed in this case, and that was related to the possession of marijuana charge. D2 was the motion to suppress any and all evidence located from the defendant's home. D3 was the supplemental motion to suppress any and all evidence located from the defendant's home. D4 was the order granting supplemental motion to suppress any and all evidence. And it reads as follows. After hearing testimony, a stipulation of testimony, and argument from the parties on Monday, April the 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from the defendant's home. Based on this ruling, the evidence located in defendant Williams' home is subject to the above referenced accusation number 16 SC1, and there are 6 fours. Specifically, that just over an ounce of marijuana, it is hereby suppressed and cannot be used in evidence by the prosecution in the trial of Jeffrey Williams, signed by Henry Newkirk on the 10th of April, 2017. There was a motion for reconsideration that was filed or accepted by the clerk's office on the 20th of April of 2017. There was an order, that was D5. D6 is there was an order by Judge Newkirk entered on the 24th of April 2017. The order, it reads as follows. The court, having read and considered the state's motion for reconsideration, the same is hereby denied. D7 is a motion for null pros on the same case where Mr. Steele filed a request to have the accusation null pros. D8 is the dismissal for want of prosecution. When the case was called for trial, the state was unable to proceed, and Judge Newkirk has the following reason: the motion to suppress was granted, and he granted the motion to suppress, and that was the 3rd of April 2017. There is a exhibit from our last hearing on the 17th, D9, which is a letter that was written by Mr. Steele to Mr. Charlie Bailey, Esquire, May 17th of 2018. The State of Georgia versus Jeffrey Williams, accusation 16 SC1444444. Dear Mr. Bailey, I hope that all is well with you and your family. I'm writing you to pursuant to my representation of Mr. Jeffrey Williams in the above referenced case. As known, the Honorable Court suppressed all the evidence in the case was null pros and prosecution is ceased. Mr. Williams has been attempting to obtain his property that is lawfully his concerning the above referenced case. The City of Atlanta is not releasing the same as they still have the same marked as evidence according to Mr. Williams' father. Could you please assist in having the property released to the lawful possession of Mr. Williams or his designee? Please call upon receipt to discuss the above. I look forward to speaking with you soon. Signed, sincerely, Brian Steele. Copies to the two Williams, one being the defendant, one being the senior, his father. D10 is the warrant for search and seizure. And those were the 10 exhibits that were admitted for the court's consideration on the motion on the 17th of November.